service and ABC News.
On the cockles of your heart or your automobile, one of the two. It's 7 degrees, the last report. Do you believe that? Oh, what do I think this is, Michigan? Every time I say Michigan, I put my thumb in my eye. Why is it? I'll wrestle it to the ground. We had a little fun earlier this morning. We're going to get into some pretty good subject matter here. We have with us, as our honored guest this morning, Owen Mullin, who's, I call him Oni because I guess everybody I know does, whom I've met on occasion prior to this, since his law partner is a very good friend of mine. Oni, welcome to our WNTS microphone.
Nice to be here.
Just lean in there close and
okay.
We'll get you good. Now, you are, of course, as I've mentioned many times in promoting your appearance here, one of the top criminal attorneys, criminal defense attorneys. I don't know if that's the correct phraseology or not. Alleged criminal defense.
Well, I consider that criminal, not a noun in my case, but an adjective. It goes with the criminal defense attorney. As far as my being a top one, that's faint praise for the rest of them.
You've been in the business a long time. Give me a little of your background, if you will, and for the people.
Well, I was born on the south side of Indianapolis. My mother was from Ireland. My father came from an Irish family from Edinburgh, Indiana. And I went to St. Patrick's Grade School, Manual High School, when it was downtown practically. It's wood now.
How'd you escape Cathedral?
Well, that was simple. It was the Depression days. They wanted lab fees, and Dad was a mailman on the south side, and Mom had other children to worry about besides me. But by the time my brothers Jimmy and Tommy came along, they did go to Cathedral.
Okay, well,
they had a little more money. Dad did.
Now,
I went to Butler, and then I went to Indiana University Night School for law.
Okay. Now, you've been in the business how long?
25 years.
Oh, just a newcomer then.
Yes.
You've probably defended some well-known alleged criminals, and I'm sure some to the point of success, others not. In the past, what can you recall as some of your more famous clients, or infamous clients, as it were?
Well, I hesitate to discuss any of these, particularly the ones that were found not guilty, because they've convinced themselves, I think, throughout the years and since the verdicts that they were never guilty at all. And were I to mention their names, they might get mad at me.
Okay. Have you ever dealt with a murder case in which when the electric chair was still actually being used?
Yes.
And have you ever lost a case in that? Or?
No, I've never had anything beyond in those days I never had worse than a second-degree murder conviction back in the days before Furman versus Georgia, when the death penalty was at least being talked about and prosecutors were asking juries to kill people, yes.
See, now the last person that was executed in the state of Indiana, if memory serves me right, was back in the 50s, and I think it was Robert Watts, wasn't it?
Well, he was not the last one. He was the more famous one around here, yes. His name was Watts. I did not remember his name was Robert. He was a black fellow accused of several first-degree murders allegedly committed in this county, yes.
Recently, there's come up, and this is probably more pertinent to what we have going today. Recently, there's come up the question of whether the criminal punishment system is what it should be. Example, M. Stanton Evans had an article which you may have seen in the news a couple of days ago.
I did see it.
And I think the summary of the entire thing was that a famous criminologist had written a book, and his final judgment was that the reason for the rise in crime was, perhaps simply put, was that we failed to punish our criminals.
There's something to that. On the other hand, we also punish ourselves by the neglect of the institutions, neglect of the human beings that we put away. And I do find great merit in some things that Mr. Stanton Evans said, or M. Stanton Evans said, and others who have criticized the system. But my main criticism is we don't have enough courts.
What is the situation there? Well, I had Jim Kelly on a few weeks ago, and he said that it would cost about $250,000 per year for another court. With all the trappings and things, they have to have record-keeping devices, bailiffs, etc. I assume this would be an accurate figure.
I think Jim's about right on that.
Now, and yet the Law Enforcement Assistance Administration has appropriated, millions, maybe $1 billion, whatever, around the country for fighting crime, and they've put it in anything from street lights, which I suppose in some neighborhoods isn't all that bad a deal either, on into law enforcement agencies. But very little, as I've been able to see around the country, has gone into courtrooms.
That's right. It's going into bureaus, and these bureaus will tend to grow and increase to the point where they would be dissatisfied with a lower crime rate. Put them out of a job.
Yeah, well, how long does it take now in Marion County? How long does it take to get a criminal case heard now?
Not too long.
There's a what is the story in the new law and on the time limits? You have to try them within a certain period of time.
If a person's out on bond on a felony charge, he must be brought to trial within a year unless he does something to delay the disposition of the case. If he is in jail and wants an early trial, he must be brought to trial within 70 days of his request for an early trial, and not later than 6 months after he goes to jail on the charge.
As a defense attorney, which is apparently your specialty, I've assumed that. Am I right?
I do nothing else.
Okay. Now, as a criminal defense attorney, then, what do you think about it? Are you ready for trial within 70 days?
In most cases, some of the murder cases, no. Some of the kidnapping or robbery cases, no. But in most cases, you're ready within 60 to 90 days. And if your man's in jail, you have to accelerate that because he doesn't want to stay there.
Mm-hmm.
He wants a trial.
Now, have you ever had to defend a man who you felt was guilty or, in fact, knew was guilty?
Morally guilty?
I mean, where he told you, hey, I did it. What do we do now?
Well, I never asked that.
Oh, you never asked?
Never.
Well, how do you handle that? You're a man of good moral principles. I know that from your past record, from talking with your law partner, whom I know very well. And how does a man say to himself, boy, I just really feel like this guy is guilty, and yet I've got to defend him? How do you handle that?
Well, my judgments and subjective thoughts about his moral guilt are certainly irrelevant to the question before the court, which is, can the state of Indiana prove this man guilty legally beyond a reasonable doubt? That's the question in the lawyer's mind all the time, not his own subjective, whimsical notions as to why did the fellow do this? It looks as if he did it. The witnesses say he did it. That's not the point of the case.
What do you think is the weakest point in the prosecuting side overall, as a general rule, in criminal cases? Their presentation of evidence, the way they obtain it, the uncertainty of witnesses, which is kind of a built-in thing. What would you put your finger on as the weak areas of prosecution?
I don't know that there are any particular weaknesses. You did put your finger on something. The state often must depend on one or two persons to get on the witness stand and tell a jury or a judge what happened. And these people do not come across, we'll say, well to the finders of the facts. And a jury or a judge is not swayed by them, even though they may be very honest and doing the best they can. There's no way a prosecutor can predict that happening. He's under a duty to go ahead as long as the fellow is saying, I saw the man rob the place, I saw the man shoot somebody. No, I don't think of any particular weaknesses on the prosecution side. For instance, presently, Mr. Kelly, Jim Kelly, our present prosecuting attorney here in the 19th Judicial Circuit in Marion County, has got a very bright group of young people, and they're learning all the time. They're getting tougher to deal with because of the experience they're gaining. But just like any other trial lawyers, these prosecutors, whether it's Mr. Kelly himself or on down the line with his helpers, they have to deal with human beings, and they have to try to convince juries to do something that most juries do not want to do, and that's deprive somebody of their life or their useful life.
And yet, I've been told by people who specialize in defense work that the feeling is today of defense attorneys that when they go in there, their man is guilty until proven innocent. Now, is that accurate or not?
Well, it all depends on who your judge is, in my opinion. And in a jury trial, that's why it's so important that the defendant's attorney, along with the prosecuting attorney in criminal cases, gets a fair chance to select the judge. And in jury selection, or voir dire as we call it, you select your judge by selecting your jury. If the judge himself, the impartial referee sitting on the bench, watching all this, gets into the case, we'll say on the state side, so that the jury panel picks up his predilections and his ideas and his pre-slants on things, well, then your man's in trouble. But I think 99% of winning a criminal case is knowing what the judge, that is the man on the bench, is going to do, and knowing how much tolerance he's going to give you in selecting the real judge, which is the jury.
Mm-hmm.
And I do not believe that the man is guilty until proved innocent under the present system at all. I win most of my cases. I think most defendants' lawyers do win most of their jury trials.
Why do the cop pleas then?
Plea bargaining? Plea bargaining is a very realistic approach to the case you're afraid you might not win. I personally do not believe in plea bargaining. I've been quoted on that, and people stare at me because they know I have done it and done it extensively. I don't believe in it. I think our jury system and our criminal justice system should be set up so that the jury can select the right remedy or penalty and not have to be stuck with, say, the man has to go to the electric chair or else he has to be turned loose. The man has to do 25 years, or the man has to do 5 to 25 years, or he has to do 10 to 20 years. When the realistic approach might be the case, the jury should have the right and the duty to pick out, say, maybe the 1 year the fellow ought to do, or the 5. And plea bargaining is an attempt by the lawyers to get their man the proper penalty in a case where they think the state can prove the case beyond a reasonable doubt, but the maximum penalty does not seem fair in that case.
Now, do you have trouble as a defense attorney getting paid?
That is, it's been an old joke for years among criminal defense attorneys that's the worst part of the practice. In fact, some lawyers say the only thing worse than no clients is clients. And they mean not only that, the whining type of client who worries you to death and gives you $10 and thinks he owns you, but they also mean the fellow that gives you a little more than that but owes you a lot more and won't pay you. And once the case is ended, you do not get paid, even though a jury, for instance, perhaps has been swayed by the attorney's pitch, we'll call it that if you will, Ron, and the defendant himself had little or nothing to do with the happy result for him. He walks out of that courtroom thinking he won the case by himself and glad that he outsmarted this so-called sharp lawyer. We have trouble getting paid.
What do you do about that?
Well, I sued one fellow in my life over a fee in 25 years, and he promptly filed a complaint against me with the Indianapolis Bar Association, which I thought was ironic, but it happened. I had won a jury trial for that fellow, too.
That's too much.
And here lately, it's getting worse. The
you have
economic
to get your money up
program is
front?
worse. Yes, you have to get it up front, and that is a principal reason for some delay in some cases. However, the older I get, the more I agree with Judge Saul I. Rebb, a former criminal court judge in this county for many years. He said if the defendant's attorney in a criminal case doesn't have his money in the first couple of months, he isn't going to get it anyway, so he might as well try the case or get out of it. And he's right. I've come to that notion.
Well, people forget that attorneys do have to live, and they have tremendous expenses and so forth. We've got a call, and then there's some other things I want to ask you about. So let's take a call. If you put that headset on there, Oni, and you'll be able to hear the telephone. That's WNTS. Thank you for calling. You're on the air.
I think you've had so many good guests lately, Ron. We can't understand it. I was wondering, after watching the television last night, about the pre-taped editing of the trial. How do you feel about that?
Well, I happen to be the attorney that Judge Wilson was talking about that made both of those tapes.
Oh.
And I'm dead set against it.
Well, I'm glad to hear you say that. I sat there, and the thing that entered my mind was, maybe I was taking the pessimistic side of it, or the dark side of it, but to me, there seemed to be so many ramifications when you start editing. How are you to say that? I don't know. It took the human part of it out, actually being in the presence of your jurors. Your lawyer and your defendant and all, to where they could possibly, the defendant could see and hear, and they could see and hear the witnesses. But I sat there and I couldn't quite put my finger on why.
What was the case involved here? I missed that somehow.
Are they really going to do that, though? I mean, is that going to become the law of the land?
I hope not.
I hope not, too, because I think, to me, it's scary, and like I said, I don't know why.
What was explain to me a minute, Oni, and hang on a minute, ma'am. What was the situation? Pre-taping of what?
Well, in one case, it was a case of pandering and prostitution against a woman accused of that. And the trial was very quietly videotaped in total, but it was not disruptive. If you could keep your eye from glancing furtively at the camera and being a ham actor, it was not disruptive sound-wise or anything like that. The second tape show that was done, that I was involved in, involved the thing I think the lady is more worried about, and that's where the human factor and the human quality is just almost entirely missing, and that's where the prosecutor and I spent several hours in the courtroom, just us together with the witnesses, and the thing was then taped in segments. Then they had the trial. We gave a live opening statement, each side did, and then the videotape of the witnesses, not the people themselves, but the videotapes on the sound and the picture of the witnesses, was projected onto a large grainy screen. Then we were permitted to give our final arguments.
Now, what was the purpose of that? What would be the purpose of it?
Well, allegedly to save time for witnesses, the doctor who can't get away from his office, but the prosecuting attorney and the defense attorney could go to his office and sort of accommodate him. The fact that an expert witness might not be available to prove something about a question document or with the presence of some dangerous drug or something like that, or identify an exhibit, might not be available in the summertime, as the judge says, when he's on vacation, but might be available some other time. You could take his videotape deposition, we'll call it.
Well, this was more or less an experiment then.
It is innovative, it is experimental, and Judge Wilson, I think, would like to see nothing else but that come in. I do not see this happening. The lady, I think, put her finger on it. Human beings should judge human beings, not flickers on a screen.
Well, not only that, though, but, you know, I think something else that bothered me was the fact, what absolute surety did you have that the judge, in his editing, didn't edit something that he thought may not be pertinent, but that the defense or the prosecution or the jury might think was pertinent?
I did not like the editing. If I have, for instance, a 73-year-old lady charged with something real vile, and she, in order to get to the witness stand in front of the jury in a real trial before with human beings involved and no TV or videotaping or anything like that, if she, for instance, would walk to the, just her walking to the witness stand and taking the stand, perhaps in the condition of her life or shape she might be in, half blind, maybe lame, something like that, that would help her to a certain extent. But in the videotape version, it would show Joe Blow, the police officer, on the stand, and the next frame or slide would show the lady defendant sitting in the witness stand. No, how'd she get there and where'd she come from? It takes something away from the jurors and being able to size up the total person. I think every case is somewhat the same and yet somewhat different. And I think the jury ought to see it all.
And now I'm
avoiding your subject about the judge editing. Judge Wilson and I have had many round arguments about that. Judge Wilson has often told him he's a fine judge. He has intellect, he has integrity, he's innovative. And he was also a deputy prosecutor for 9 years before he took the bench.
There was one more thing I wanted to ask or state and get your opinion. When you said you didn't think that it was foreseeable in the near future, or maybe never, well, putting words in your mouth, but from what I understood last night from the show, it has been in practice in Ohio for maybe 4 or 5 years. And to me, it's almost Orwellian and 1984-ish. And there again, does that preclude the press from being there? And does, in eventuality, does that preclude people wanting to observe trials and press? I mean, is it going to come to a closed society and a closed court and no human factor involved in anything? That's the thing I think that bothers me.
I understand that, and those thoughts have crossed my mind, and I do worry, and I do know about the Pennsylvania situation, which is experimental, also the Ohio thing, which is apparently getting a little grip. You were right, it is Big Brother stuff. It's only one phase of much Big Brother stuff that this crime crisis we're in is causing. It's causing an overreaction in many areas. Mm-hmm. For instance, yesterday I listened to I thought one of the more fascinating interviews I ever heard was to hear it with Mr. Hofer on WNTS. I guess his name was Bierman.
Yeah, Bill Bierman.
Right. And I listened to that fellow, but I became fascinated by it. And in passing, the subject came up there about how if you rob a bank, I guess they have banks in Russia, or you pull a robbery there, why, by the next morning you're caught, your jury is selected, and that's the last you ever heard of. Now, it would be quite easy, of course, for the Russians, or if that is their system, and I don't know that, to pick up Ron Hofer, who has been caught looking askance at some government publication, and say, Ron, we're sorry, but you robbed a bank this morning. The jury's going to find that to be true, and you're gone, you're dead, or you're in Siberia. We will show a picture of this later to the public so they'll know that you had a fair trial. Yeah, the bugging, the wiretapping, the videotaping, the editing by judges, the editing by...
That's what scares me, the editing.
Yes.
Yeah, that's the scary part. That's true. Because believe me, if you talk to any person in the motion picture business, I'll guarantee you they'll tell you the editing can make a movie.
That's right. There you go.
Yes, ma'am, I think you put your finger right on the part I object to. I do not want to be held in contempt of court by Judge Wilson. I have expressed these things to him privately, but never for the whole county.
I didn't want to put you on the spot, but...
No, I don't mind. I'm getting so old that my principles I'm starting to rise above principle. We'll put that way.
Well, there was just one more thing that I wanted to say, and then I know that there's probably other people wanting to talk to you, but I forgot what it was.
You'll think of it.
Well, you know, when you were talking about the different societies, like in Russia, I mean, we use that as the main theme. But now I have heard, and I don't know how much credibility it has, but I have heard that we do have sort of a system here. We have political prisons here in the state. Here in the United States that people really are unaware of, like there's one in Springfield, Missouri, that people aren't actually in total picked up off the street and whisked away, but almost so, by possibly a bad rap or by an assumption that something was done and that they are kept there. Do you know anything about that?
No, ma'am. If that's true, it must be a reference to the federal institution there where a lot of psychiatric work and examinations are conducted for this area. I have never heard anything that devastating, however, about that.
Well, evidently there was one past congressman, Dowdy or something, I think was his name, that when he was released, he was a guest on a show one night, and supposedly that's what had happened to him, and he couldn't get his story out in its totality. But anyway, I'll drop that because I can't remember.
I'm not familiar with that, ma'am.
But anyway, it's been very nice talking to you, and I'm glad also to hear that you are not absolutely for plea bargaining. I do not like plea bargaining.
No, I do not either.
Thank you very much, and nice to have you on.
Thank you for your call. WNTS, you're on the air. Go ahead, please.
Yes, good morning.
How are you this morning?
Oh, real good. Well, I had a question about what the gentleman thinks about like professional juries, where, juries are normally, selected, I guess you'd say, from the voting populace. And I think there's merit to this, but at the same time, I've wondered about, the aspect of professional juries, where actually this would be their profession, so to speak, or at least temporary profession.
What do you think about that, Owen?
Well, surprisingly enough, the judges have regular panels of jurors. And these serve, if not stricken off through peremptory challenges or challenges for cause, as we call them, by particular prosecutors or defendant's attorney, when they do appear for the duty, these folks generally serve at least 3 months and hear 7, 8, 10 cases and become quite skilled as jurors under the present system. I personally do not like the professional juror approach from a defendant's standpoint now. And don't get me wrong, these people are all honest and they're all trying to follow the law, these jurors, no matter whether they've served on one case in a term or 12. But I personally think that we should take the people from the voting list as we now do. In other words, if you're going to be 18 by the next general election and you're only 17 now, you ought to be called as a juror on up to persons over 100 to serve. They don't have to serve after they reach the age of 65. What I'm getting at is I'd rather just have the cross-section of the people from the vicinage, as the old-timers used to call it, from the neighborhood, rather than the professionals. Now, most judges would agree with you in your concept, and it is being done to the extent I've mentioned.
Okay,
regular panels.
I've got to run on that. Well, thank you for your question, sir.
Thank you.
Okay, we got to make way for the news. We're going to be right back. We're going to bring on Bill Butler, WNTS Indianapolis. You're on the line. Hang on. We'll get to you right after the news. Mullin. However, we have certainly one of my defense attorneys here in the studio, so don't pick on me this morning. Owen Mullin, the senior member of the firm of Owen, well, it'd be Mullin, Foley, and Gilroy. And I said Laswell yesterday, and Laswell used to be with him, but that was my mistake. I'm glad you corrected me on that. And it didn't hurt much when you twisted my arm either, only.
Okay.
A couple things I'm going to ask you about before we let you out here. But we've got some callers waiting, so we'll take those. Look at those calls come in. Do you believe that? We may make you stay past an hour if you got the time.
I'll be glad to.
Good. I hope you didn't miss church this morning.
Oh, no.
Oh, okay. Go back to the phone. You're on the air. Go ahead, please. Hello.
Hello.
Yes, you're on the air. Go ahead.
Sorry, I didn't hear the click. I'm just curious to know if something comes through on my television, does come through on anybody else's.
Why is that?
I don't know what that lady heard last night, because I watched it too, both my husband and myself.
Mm-hmm.
The judge said that this method of conducting a trial would not apply in every case. The public can sit in and view on split-screen television. He also said that all that would be cut out was irrelevant and immaterial material.
Now, doesn't that become a matter of judgment?
Such as how, and Mr. Mullins, is that his name?
Yes.
Cited it himself. A poor, pathetic 73-year-old woman who probably shot her husband, how she walked to the stand. What possible difference could that make?
Oni?
No, it could make a difference, but that is immaterial.
Well, wait a minute now. Okay, Oni, you got any answer to that?
Well, I did watch the program, and I do admire Judge Wilson, and I did hear what he said. But I do not think that everything that judges say is the gospel. And when we get into this subjective area, what's irrelevant, and what's material, and what's immaterial, then that's a judgment call on which maybe you, your husband, and I, and the judge would not agree.
Well, he also said that the attorneys could sit in on the editing of the tape, and if they had an objection, there's room to file an appeal, and they can sit in and discuss what he wants to take out and everything. Now,
in the back room of the court, which is not the place to decide such things.
I beg your pardon, I didn't understand that.
I believe that everything should be decided in open court, just like the Constitution says, not in the back room with the defendant's attorney saying, "Judge, I had a point to be made here."
Oh, okay.
And the demeanor and the appearance and the way my client walks and talks and everything about her, the Supreme Court of Indiana says must be brought out and observed, just the same as for any other witness.
All right, now you tell me this then. If everything should be out in open public court where the jury panel can see it all, how come the attorneys and the judge go back in chambers and have their little chit-chats right during a trial?
They do that, ma'am. They do that frequently, and I personally do not favor it. I do not favor bargains being struck in back rooms. I think everything should be in open court. And the idea that any case would be settled in a back room while the jury and the public milled around outside wondering what part they were supposed to play in the case is abhorrent to me, too. It is done.
Yes, it most certainly is. I got one other thing. You talked about a permanent jury, you know.
Yes, a gentleman did ask about that.
Okay. Well, you know, the way they select a jury today, I do not approve of at all. If you remember back years ago, the people who sat on juries were property owners.
Yes, that was true.
I think that was done for a reason. I always figured that they thought if a man had gumption enough to own property, you know, I mean, it was a steady working man, and he had gumption enough to own property, that he might have a little bit of gray matter up here. But now they change it and they go to the voters.
The United States Supreme Court decided that, ma'am.
No, I don't know who decided it, but don't that tell you something?
It tells me that the jury should be selected from the broadest possible spectrum, and there are some persons who are very fine, responsible, honest people who do not believe that your ownership of a piece of property should determine whether or not you sit on a jury.
Well, that may well be true too, but I don't think there's a lot of people who are selected for jury.
People get older, for example. Let me tell you what happens if you make it property owners only, and how you may miss some great prospective jurors. Here's a man perhaps a woman who've raised their kids and decided that their 12-room house is a little bit too big, so they do what many, many people do nowadays, and they go out and rent an apartment. They sell their house and rent an apartment. And still, you know, are members of the community and are very intelligent people and not necessarily senile.
All right, I'll go along with that.
So there you have, really a portion of the population would be automatically excluded, and really it's very large. This happens frequently, as you probably know.
You're right about that. Okay, so you shot me down on that, but I'm a firm believer in this business that I think the idea that the judge had was fine, that you can watch watch the defendant, and you can watch, you know, you can watch so many different people on this television screen that you ordinarily could not see when you're just sitting there, when the jury's sitting there. They have to look at one or the other.
In other words, they have to keep their mind on their business and try to judge the human being and the witness. And I think the amount of time that takes is infinitesimal compared with all of the time you take to prepare this television pre-taped thing where the lawyers, that is the prosecutor and the defense attorney, spend endless hours, you know, maybe a week getting ready for an hour trial. The judge, he doesn't care about that. He's not concerned until it comes time to edit the thing. Then the judge edits it the way he feels that it should be done, even though he wasn't in court at the time the context of the evidence was developing. He was someplace else. No, I don't like the tape trials. I do like the jury system as we now have it. And I do like the idea of human beings judging human beings. As far as the split-screen TV and all that, it's very pretty and all that, but and it's very electronic, and as one lady said a while ago, that's scary in itself.
Well, that's true, too, but now I'm sure you know yourself that there has been a lot of cases where there have been some people who came into court before a jury that were a totally different person the day they walked into that courtroom. I'm speaking, well, should I put it this way, and I've got young children, so I'm not against young children, but some of these young hoods that go out, they get their hair all cleaned up, they bring their crying mother in there. 2 days after they're let loose, they're back on the street doing just what they've done before. Now, that does make a difference.
Well, you're talking about defendants or young jurors or
Well, I'm
just
talking about defendants.
defendants now?
And I think that does make a difference. And one more point, and I'm going to get off, and I think I've got a case of discrimination going here. I think non-voters are being discriminated against.
Well, you don't have to vote. You simply have to register to vote. You don't have to vote.
Oh, all right.
Okay.
They might also be very important.
That's
Right.
true.
Thank you.
Thank you for your call. What about the witness cleanup? That does happen.
Yes.
It's done by design. Of course, you're there to do the best job you can for your defendant. I've seen it happen in several cases with a plaintiff and or defendant.
I did it recently in a case. Jim Brand, a very fine attorney in Greenfield, good friend of mine. We worked a lot of cases together. We decided that the fellow would look neater if he had his beard and hair trimmed, and he did. And it did not hurt him.
Did you win?
That was a plea bargain.
Oh.
That was a plea bargain.
Okay.
I think it was a victory, but the man's going to have to do some time in spite of the fact that he's a young fella and has a beard. He's going to do some time.
Okay. WNTS, you're on the air. Go ahead, please.
Good morning.
How are you this morning?
Pretty good. I'd like to ask Mr. Owen Mullin a couple of 3 questions. One, I've served on numerous juries. Why, a lot of times, are jurors questioned that they feel sometimes that they are on trial instead of the defendant?
Well, sir, that's easy to answer. Let's presume the impossible. Something would never happen. You were, we'll say you're accused of murder in the 1st degree. And you get an attorney and you say, now who's going to decide this case? Well, we'll say for all practical purposes that we're going to pick 12 people. Since you're charged with 1st-degree murder, we get a chance to strike off 20 without any reason. If we can develop a cause, if they admit they couldn't give you a fair trial because you're a white man or because you're a black man or something like that, or because they have a preconceived idea from reading about the case or hearing about it on WNTS or something, we can strike off people like that for cause. In order to find out this cause, we have to ask a lot of questions. And you would say, look, I don't care if it takes a month. I want the best, most honest people who will favor me. Take a month if you can to pick a jury because they're the judge in my case, and this means a lot to me because I'm morally innocent of this crime. I'm a victim of circumstances. Now, as a practical matter, in Marion County, in the criminal courts of Marion County, we are being heavily restricted by the judges. There is no more intense questioning permitted. It's down to around 20 minutes in 2 of the courts. 20 minutes to pick a jury in a case involving maybe 20 years of a defendant's life. What can you find out about 12 people in 20 minutes?
Well, is this 20 minutes for the whole jury or 20 minutes for each jury select?
20 minutes for the whole jury.
Well, this has been changed a lot.
Yes, it has radically, no doubt, since you've sat. This is an innovation of the last 2 or 3 years.
I was served under Judge Rabb, and I think it was Judge Fife. This was Criminal Court 1.
Yes, he was in Criminal Court Division 1, Judge Eugene Fife. He died in office, as you'll recall.
But you made a statement a while ago about a Judge Rabb.
Yes, that's the man I was referring to. Judge Saul I. Rabb was in Division 2 of our criminal court. Yes, sir.
He is a very fine judge. I served more under him.
I thought Judge Saul I. Rabb and Judge John T. Davis of Criminal Court Division 1, I think they are now two of the most brilliant legal scholars in the criminal law, and wise men, too. Very fine judges.
Well, this is, you cleared up a good question there for me, for I know you did question me extensively on a case. He was an ex-boxer in a license plate scandal.
That was Tennessee Lee. I'm not afraid to reveal his name. He was convicted.
I will let you mention the name. I noted, but
It's on the public record.
And you might remember me. I don't know.
I probably do. I made a mistake in that case. I didn't put my defendant on the stand, and that thought has haunted me for years.
Yes.
I made a terrible mistake in that case. As far as my questioning you intensively, you must remember the atmosphere in those times. The Republicans were claiming that the Democrats, who were in charge of the license branches, were cheating and making extra money, and that persons were getting license plates who did not, in those days, hadn't paid their personal property taxes. You know, that was a requirement then, no longer. And the atmosphere was highly politically charged. And that was the reason for all the intensive questioning. But that kind of questioning would no longer be permitted in Marion County. It's still permitted in most of the counties elsewhere in Indiana, and either way is right under the present Supreme Court rule. Yeah.
Okay, thank you.
Yes, sir.
Thank you for your call. Thank you for your call. Appreciate it. Okay, Owen Mullin, senior partner of Mullin, Foley, and Gilroy. I had to get Gilroy's name in there. He'd kill me if I didn't again. And I got some other calls waiting here. And I want to question you about some things myself. So we'll get right on with it here and let the people who've been waiting get with it. You're on the air. Go ahead, please.
Hello?
How are you, sir?
Fine. Ron?
Yes, sir.
I couldn't hear you. I want to talk to Oni about a deal here.
Oh, okay.
I served on a jury a while back. We had three very unstable women. One of them had to go to her doctor to get a couple of aspirins. The other one was very visibly pregnant. I wouldn't have had her on the jury, and she got hysterical. As a result of all this, you know what happened to the trial.
Would this be on the Roberts case?
Yeah, you recall the trial.
It was ended in mistrial.
And one of the gals got to our good friend Tom Keating, who you know and I know. And she said some very things which weren't true. I'm the guy that said a woman could be raped in the back seat of a Volkswagen. I didn't say I had done it, see. But she implied that. But the thing was, these gals were scared to death of their life if they convicted this guy.
Have they had any threats or anything, to your knowledge?
No, other than just looks they said they got in the courtroom from his friends. And to me it was the most frustrating thing to sit in that room and see these three women just go to pieces. See what Oni has to say about that.
What do you think, Oni?
Well, the main thing I think that will be corrected in the event of any trial like that or similar to that, or on a retrial, which is legally possible, would be to get more alternate jurors. Judge Tranberg is a fine judge, and I admire him and respect him, and I'm certain that if he were here, he would agree that he possibly could have used more alternates to avoid the mistrial, all the expense, and the fellow having to go through another trial again, the prosecutor and the alleged victim having to go through another trial again, all these things. Now, I talked to the attorneys on that case, two very fine attorneys, Michael Riley and Richard Sallee, represented that defendant, as you'll know, as you recall. And the prosecutor, I believe, was Charlie Johnson.
Yeah, he was.
And by the way, I've noted the Star has been hitting on Charlie as the most boozingest deputy prosecutor and all that. He's a fine attorney.
Sure is.
And I hated that. I happen to respect his ability very much, just as I do Riley and Sallee. And all three of those men were just worn out, too. Emotionally, they're drained by that thing. Is that the feeling you had as you sat in there and had to go through all the...
And it was... well, you could tell when these gals said, or two of them said, we're locked up here. I feel like the walls are coming in on me.
Now, let me ask you this. Were there the obscene jokes and so forth going on that were alleged or not?
No, sir. No, sir. Any obscenity they saw, they thought up themselves. As I told you, the one guy said a woman could be raped in the back seat of a Volkswagen. And I know you, Ron, and you're as big as I am. I'm 6'2" and weigh 220. We could manage it.
That has been done by bigger people than us, I guess.
But it was just frustrating to me, and I put in my time and on the jury, and it was very obvious. And what got me here, this poor gal has to go through all this again. You know, she had been raped. Her baby had been laid alongside the road and froze to death. And here she's got to stand up again and have some guy like Oni. I'll pardon you now.
Oh, I don't take that personally.
Her and every damn thing brought out again. And here we were. We could have settled that the first time. But there was 3 unstable people on the jury, and they had nothing in their mind about as to whether he was innocent or guilty. All they was worrying about was themselves. One got real sick, one got hysterical, one, it was, well, you would have had to have been there.
Sir, would you agree with me that the architects and builders of the city-county building, although they built a very beautiful courthouse wing for the heavy courts, as we call them, circuit, superior, and criminal court, and probate court, in the west wing of the city-county building, and nice airy courtrooms and very pleasant atmosphere, that when they came to the jury rooms, where you're going to have 12 people
you couldn't say
stacked in there, in a boiler room atmosphere, perhaps sequestered as you folks were, toilets jamming up, paper cups flowing over. Isn't it sort of like being packed into a fraternity initiation where they deliberately try to goad you into doing something emotional?
That's the way some of these...
the jury rooms are not large enough to accommodate the people.
You're right there.
They give you more room than that over at the Marion County Jail.
Well, Oni, take care, and I hope you win them all. Ron, thanks a lot.
Thanks for your call. Interesting man. You could almost bring him on as a guest and tell about that zoo, apparently, what went on. That's something else. Oh, boy, let's see. Where was I, folks? I think I am over... Here. Go ahead. You're on the air.
Mr. Mullin?
Yes.
A while ago you mentioned you don't ask a client whether he's guilty or not.
That's right.
When you have chronic offenders, and it's been proven by witnesses the man is guilty, do you still not care to ask him, is it just still your intent to have the state prove it regardless of whether you feel that he's guilty or not? Is that the thing that's uppermost?
I didn't mean to give the impression I was indifferent to the matter of guilt. I have to be very conscious of what witnesses can prove, what they will say, what appearance they will make, what their demeanor is, whether they themselves are worthy of belief and credit. And I must evaluate the case. What I actually do when a person comes to my office and admits he's in there to see me because he himself has been accused of a crime, or if I'm called over to the jail where some fellow's being held because he's being accused of a crime and hasn't made bond, I simply ask what he knows for sure that they can prove on him and who is saying these things, and I start from there. I'm bearing in mind my attorney's oath, which says I can't refuse to represent people merely because I might have an opinion about their guilt or innocence. I'm bearing in mind the statute of the state of Indiana, which thrust upon me the job of being on their side, is what it amounts to, and bearing in mind the constitutional right to a fair trial and the duty of the prosecutor to prove these horrible things beyond any reasonable doubt as to all the important material elements of the case. When you get that panoply of things to consider, then yes, I don't care what anybody says. If somebody's there, I don't care if he's got a record, I don't care if he's got a hair lip, I don't care if he's black, I don't care if he's white, I don't care if he's the lame, the halt, the blind, whatever. My duty is clear. When I said I do not ask them if they're guilty or not, it's because my subjective opinion as to their guilt or innocence is irrelevant when we look at the things, steps the law sets out. And I think we all have to have somebody we can talk to. And I think a fellow ought to be able to talk to his lawyer in confidence and tell him things that he knows the state can prove or can't prove. And I think that lawyer's lips should be forever sealed.
Sir, I hate to cut you off. I've got to run. We got the network coming up.
Ron?
Yeah, I'm with him because we've got a gentleman holding here. Our guest is Owen Mullin. Owen, we want to thank you for staying an extra hour here for us. And I know on Sundays it's not always pleasant to work. But we have a gentleman who had some further questions when we got cut off by the news. So go ahead, sir. You're back on the air.
Yes, sir, Mr. Mullin. In regards to whether you're not really asking your client whether he's guilty or not, I know that a good criminal attorney can rationalize just about any question. If you had seen a man commit a holdup and he did not know you seen him and later engaged you to be an attorney, would you disqualify yourself or still go on the scene?
I would have what is known as a tremendous conflict of interest, and I could not represent a fellow under those circumstances and would not. In fact, I would have reported long before the man ever got a chance to contact me. I would have been reporting that to the police authorities, that I was a witness. We don't have enough people coming forward on these holdups the way it is.
Is it all, you said you could mention the name of someone you defended that was found guilty.
Yes.
Would the man that escaped several weeks ago from Atlanta Penitentiary, is it all right to mention his name?
The man who escaped from the Atlanta Penitentiary was never convicted when he was my client, so I'd rather not mention him. Let the lawyer who represented him on his defeats handle that.
Well, he was caught several times, isn't that right? He was caught.
The person we're talking about is the person who has twice escaped from maximum security federal institutions.
Right,
I think I know who you mean. I'm certain that I do. And he was accused of several crimes, yes, sir.
And he was caught several times, and I think it's safe to say that it's probably a few times he wasn't caught.
I have no idea.
Well, when he would engage attorneys and would come up with attorney's fees, his brother and the rest of his friends were very active at that time. Was there ever any question among attorneys about where that money might be coming from to pay those fees, or is that ever considered?
Oh, it's considered a lot. As a matter of fact, the fellow you're referring to gave me some money. Shortly thereafter, the FBI came in and relieved me of it. So there was no question about where that money came from. It came from a bank in Fishers, Indiana, and the FBI has it to this day, so far as I know, unless the bank got the equivalent back.
Well, like I say, undoubtedly there were many times when attorneys did receive money probably that wasn't confiscated, so to speak.
Isn't it a fact also that grocers and people who run radio stations and people who drive trucks also perhaps might be handling money which came out of illegal enterprises?
Well, there we go to, like I say, a good criminal attorney can rationalize anything. On the theme I was speaking of, though, it's more likely to be in that avenue, I think.
Well, if you have a prejudice toward defendants' attorneys, yes. But as I keep saying it, putting it on a personal basis, let's assume the impossible, that you are accused and that you are in possession of, say, $500 worth of marked money, and you come in and hire me with that money. Now, you've been falsely accused. You've innocently come into the possession of this money. You didn't realize it was coming through the regular channels of trade and it was going to be used against you in a criminal act. Should I refuse to take your case?
Well, there's one difference there. If you're defending someone that is active with a group in committing crimes, you're certainly well knowledgeable about that. Whereas a fellow that just held up someplace on one side of town could go to a grocery store on the other side of town, and that person has no knowledge of that person that's giving him the money as far as that goes. There is a difference between an attorney and a grocer or a doctor or what have you in that respect.
Well, now, you've assumed a set of facts there. You're asking me what you're begging the question, it seems to me. It's like, should we say, if you ask me, should the brutal game of football be abolished? In other words, you're assuming all these facts that the attorney knows all this.
The question that I did ask.
Okay. Well, you can see that I do not believe that an attorney would be morally justified in taking a case where a fellow, he had witnessed a fellow hold up a bank or anything.
Well,
and reasoning from that thing of yours, which I think was well thought out on your part, should an attorney take money just because a fellow's got a brother that might be a crook?
Good question. Yeah, okay. What do you do about that? It's got to be a question that's a real problem for a defense attorney. What do you do about it?
What do I do about it?
What would you do about it? Let's say you're the attorney. This is your livelihood to defend people, And a man has a right to a legal defense, no matter how guilty the public may think he is through, prejudicial newspaper publicity or not. You'd have your day in court just like I'd have mine. Now, what would you do if a man had a brother who was, like you mentioned, an active criminal or suspected to be one?
Well, in this particular case, they were together, very active as a group. Very active as a group.
I understand. I mean, what would you do? I don't know. I'm not being smart enough. Pardon me?
Take the money?
Yeah, what would you do? Would you defend the man, knowing full well there would be at least a good chance that the money you got was ill-begotten gains of criminal activity?
Magic word, livelihood. That's the name of the game, it appears, you see. So a criminal attorney will probably keep taking the money unless somebody did come in and confiscate it, as he said, in this case, the FBI or whatever.
Well, I think the problem is legion, really. A man is entitled to a defense. And I'm probably one of the hardest-nosed people in anybody in town into nailing the criminal. However, it has to be a perplexing problem for a defense attorney. What do you do when a guy is, associated actively or suspected to be, whether they be relatives or not, is really irrelevant. What do you do when a man comes in and wants to hire you to defend him? Do you turn him down because he hangs around with criminals?
We're not talking about somebody that hangs around. We're talking about a criminal.
All right, an alleged criminal, a guy who's done crimes in the past. That's what I'm talking about. What do you do? I don't know. What do you do, Oni?
I don't see how in good conscience you can defend him.
I don't see how in good conscience you could refuse to defend a fellow who was accused of a crime, particularly in the case you're talking about, where I did represent the fellow, and he was not found guilty.
Well, I mean, it happens all the time, as far as that goes.
Well, I don't know how often it happens.
How many times do you ever see a criminal attorney refuse to take money that he figures might have come from that?
Oh, I can't speak for all attorneys or for all criminal defense attorneys. I can recall one instance where I accepted money, and when I found out what it was, I cheerfully gave it to the FBI. Then I disqualified myself from representing the man because it seemed to me I had become a witness in the case against him, as indeed it turned out to be. I was used as a witness on accepting the money from him. And since that was not an utterance or a confidential communication but the handing of something physical to me, it was not within the attorney-client privilege, and it hurt the man in court when some other attorney represented him, a very fine attorney, by the way.
I thank you.
All right, thank you for your call. One of the top criminal defense attorneys in the area, and we're taking calls 352-1611. Oni, we're going to clear some more of these lines. Go ahead, you're on the air.
Is that me?
Yes.
I've got a cold, but I'm going to ask a question and then get off the air and listen to the answer.
All right.
As an attorney, I was wondering, somebody who didn't make out their tax returns for 3 years, should he or should he not be disbarred?
I think he ought to be suspended. That happened to me, by the way, lady. I failed to file for 2 years, and the federal government chided me for that to the extent that I did 30 days in the Wayne County Safety Building in Richmond, Indiana. I paid my penalty, suspended by the by the Supreme Court of the State of Indiana from the practice of law for 30 days. It amounted to almost 45. And I confess my error. I was interviewed on this by Indianapolis Star. It was on the front page of the newspaper. And I said it was the best thing that ever happened in that it helped other attorneys. And I found out my family stuck with me. I had made a negligent mistake. I had committed a misdemeanor. I paid bitterly for it. I will never forget it. And I can empathize even more now with the fellows who are in the jails. Believe me.
Okay. On the next call, you're on the air. Go ahead, please.
Good morning.
How are you?
I have a couple of questions. Unfortunately, I missed the first part of the program and also the television, apparently, that covered some of this last night.
That's a shame. Now I have to send 2 thugs over to your house to beat you about the head and face.
Oh, golly. Well, I better get ready then. Okay. Pardon me. I just wanted to know, what is the alleged reason for videotaping these court hearings? What's the advantage? Save time or money or what?
I don't know. Can you answer that?
Saves the judge time. Saves the jury time. Cost everybody else a lot of time, and taxpayers be... Oh, guys, I think the expense would be tremendous if every trial were taped. And certainly that is not the law and may not ever be in the state, but it would be tremendously expensive and not very good entertainment, I might add.
Well, now, this thought occurred to me. If if someone were taped on videotape and used in place of what is now a written deposition, I could understand where that might be very helpful and might might help to arrive at a more just decision, because it would give that person, rather than bring in a written deposition from him, it would give that person exposure to the jury, and they could look at his attitude and his demeanor and the way he's dressed and his voice inflections, that sort of thing that you miss in a written deposition.
And yes, you're right. I agree with that portion of it. For instance, the case of the lady who allegedly shot at President Ford and was found guilty thereof. A videotape of the president's testimony was used as a deposition, as you have pointed out, and I think that was I think that was the right thing to do. I've also seen it done in cases where doctors were unavailable.
Right.
One witness, or even two, or even more, but as an adjunct to live witnesses before a live jury, with everybody present in the court, the right to cross-examination being preserved, the hearsay being stricken out, things like that. Yes, I favor, if you're going to have depositions, and they are permissible, where it's the same parties, the same issues, and you use due diligence and made a good faith effort, but you can't get the witness in the court either because he's busy as President of the United States, or he's a busy doctor, or he's ill, or something like that. No harm at all. If you're going to have a deposition, I'd just as soon have videotape. In fact, I'd prefer it over the written transcript. Mm-hmm.
Well, in that specific instance, I would agree that videotaping would be very good. I also agree, though, that there should be a legal or a law of some sort passed that editing was absolutely forbidden. Regardless of the time involved or anything, just don't edit it. Because when you get into editing, that's where you get your problems. Because as you have said earlier, it becomes a value judgment, and then whose judgment do you go by? And that's where your problem is. But I do think the idea, for those reasons, is good. And I'm inclined to agree with you with the rest of it, and I think there is much danger in that sort of thing. I hope that there is enough feeling against it that we don't have that in the future, because I agree with the caller earlier. It is strictly Orwellian and 1984, and we don't need any more. We've already got enough of that nonsense. And I'll be listening with interest. Thank you very much.
Thank you for your call. WNTS, you're on the air. Go ahead, please.
Ron?
Yes.
I just wanted to clarify my earlier call. I wasn't trying to interpret for the listeners Judge Wilson's case of pre-taping, but when I was listening, it just brought up in my own mind the long-range elements that might be connected with it. And for those who didn't see the show, Judge Wilson said that the initial taping machine was $20,000 for the one that he has now, if I remember correctly, and that it was $18 per tape per hour.
Now, do they have to save those tapes, Oni?
Now, that's what I wanted to ask last night, and I couldn't get in. Say that a person is acquitted. Are those tapes destroyed, or are they kept ad infinitum?
I have no real idea. This is all an experiment, and I want to assure you again now, Judge Wilson is acting with integrity in this matter. He is firmly convinced that this is the answer for the future. I believe he's saving everything now because it's all experimental, none of it recognized, and he's even going around and showing some of this to various groups to try to enlist their support for the program. I don't believe any of it's been destroyed as yet, but I'm not certain.
Well, I didn't want, also too, I didn't want to impart to the listeners either that I was questioning his integrity, because I've heard him before, and the other time I heard him, he was with a panel, and he seemed to be this in the long range aspect of it, which had nothing personally to do with him. To me, I was questioning the fact that, there again, like the previous caller had said, is this another aspect of government's high-handedness? That's the thing that bothered me, and what it could do in the future. I mean, experimental states sometimes are beautiful, but then you get some crackpots in later years, and let's face it, some of our judges now, I think, are being judge juries in your whole State Department and municipal department and federal department. They're taking, as far as I'm concerned, a lot of the things away from the locals in some of their decisions.
I heard.
I know I broke a rule by calling back, but I wanted to emphasize that I was not casting aspersions.
Oh no, ma'am. I heard you a while ago, and I thought you were very thoughtful, and no reasonable person would think you were making any ad hominem argument against anybody. It was just a thing that worried you, and you expressed yourself very well. I broke in here for the reason I do agree with you on one point, and that is there are judges, and we're not going to say who apparently believe in a government of man and not of laws.
That's the point. That
And they do not believe in the jury system.
Well,
And they don't, because they don't trust the people. They think of the people as a great beast or something.
right. Okay. Thank you very much.
Thank you for your call. WNTS, you're on the air. Go ahead, please.
Yes, is this Owen Mullin?
Yes, sir?
Is junior or senior?
Well, sir, I don't recall any other Owen Mullin, because I don't think any other Mullin mother would have saddled a person with a name like Owen. There's only one Owen Mullin in this county that I know of. All my sons have different names than Owen.
You used to be Democratic state chairman?
No, sir, I used to be the Democratic county chairman in Marion County.
Well, I just want to call you. I hear your name on here, and I listen to this radio.
Well, boy, you've got a good memory. That was back in the days of Stevenson, Eisenhower, and all that. Phil Bate was mayor for the second term.
I remember I come with you and got a stop with a railroad man that sent me to you one time. I had a little problem with the car, and I got it straightened out.
And I didn't ask if you were guilty about anything, did I?
Why, of course not. It's true. But I just want to call and thank you very much.
Yeah, well, thank you.
Oh, and I just want to call and say I'm glad to hear you on the air.
Thank you, sir.
Thank you very much.
Thank you for your call. I wanted to ask you one question before we got too far in and didn't get a chance to. I know we have the callers. The lines are loaded. But recently, your law partner, who's a super good friend of mine and a guy I've known ever since grade school, Dave Foley, was involved as court-appointed counsel for Ricky Lee Vaughn, the alleged slayer of policeman Robert Schechte. Now, let me ask you this. We talked about it before we went on the air. What are your thoughts along that line? What clarification can you give us on the allegation that Ricky Lee Vaughn called Foley a racist, which hardly is the case?
Well, of course, it's not true. Dave has freed more people, more black people, I think, than Abraham Lincoln. He's not a racist. Color doesn't make any difference to him. The merits of the case do. He's a very dedicated attorney. He's much better than I am. It's just that he's modest. As a matter of fact, I believe I'm on this program today because Dave was just being nice to the old man. He's the one that should be on here. He's not a racist. He's a fine attorney. Joe Gillardin of the Indianapolis Star did factually report what I heard in court. Now, I don't want to say anything else about the matter because I don't want to prejudice the state or the defense in the state versus Ricky Vaughn case. But I will say this. Mr. Foley is a fine attorney. And if Judge Tranberg rules that he is going to be the attorney for Ricky Vaughn's going to have himself one heck of a good horse going for him at that trial.
Okay, and what did Vaughn have to back up the allegation of racist? What would have brought that on?
I have no real idea because of the confidential communication and things, but here's an example, Ron, how your client can say anything he wants to about you, but you're bound not to say anything he's told you.
Yeah, kind of puts you in a trick bag.
You have to sit there and just eat it, just like the football quarterback that's getting sacked.
Okay.
Nothing you can do.
We'll go back to the phones. WNTS, you're on the air. Go ahead.
Hi. Wanted to ask your guest a question.
Go ahead.
Do you only handle criminal cases?
I personally only handle criminal cases. Mr. Richard Gilroy and Mr. David Foley handle any other matters besides criminal cases. I personally have not handled any in about 14 years, and the reason for that was divorce cases. I found out there was so much degradation and misery and suffering, and that it just seemed like they never ended when little children were involved, and I found myself torn between what I wanted to get done for my client and the welfare of the kids. I finally decided that I had such a conflict of interest in my own mind, not really believing in divorce anyway, or dissolution as you call it now, that I just withdrew from civil cases entirely.
Well, one other thing. I heard that the lady, I guess, who wanted to give you a black eye by asking the question, which I think you answered very well. I had no idea about what your private activities had been. But I think certainly everybody deserves someone like you. You kind of get upset when you see somebody fine that was turned loose. And, of course, you're forming an opinion that that person was guilty in your own mind. And I think that there is an excellent place for defense attorneys, and everybody should have a good or as good defense as they can have. And I think some of the people who feel otherwise should be like you asked the man, what would he do if he came into your office and he was a defendant? And sometimes people never think they're going to be in that strait, so to speak.
That's right.
You find yourself there sometimes without even knowing how you got there, and then that's when you cry out you want the best, the longest time, whatever it is, because you're involved.
Lady, that's so true. You certainly have an objective view of what really happened. That is so true. And I might say this, I did not resent that lady calling me to task about a matter of public record. I think everybody ought to be big enough to make their mistakes, and I think everybody else ought to give him a second chance.
Well, that's what I think you came out way on top because it was like she wanted to black your eye, but I thought I didn't.
Well, that was her business.
And
I'm sure she feels better about it, and I don't feel bad. She didn't make the mistake, I did.
I feel like if I were going to have a defendant, have an attorney, that would make me consider you over anybody else.
Well, thank you for that, but there are many fine criminal defense attorneys in this state and in this county. And I could go, I'd like to name several of them, but I'd leave out somebody and then everybody would be angry. I'm not the only fella, and none of those people went to jail.
Never thought about it that way. That's too much. Okay, we got Bill Butler just coming in here, and we've got some callers waiting, so if they'll be good enough to hang on, we'll be good enough to put them on as soon as we can get them on right after the news. With Bill Butler at WNTS in Indianapolis, it's 11:30. The member of the firm of Mullin, Foley, and Gilroy in Indianapolis, certainly a known firm for what has to be one of their top specialties and his only activity, and that is defense of alleged criminals. And you were on the air. Go ahead. Thank you for calling.
Hello?
Yes, go ahead.
I wanted to ask Mr. Mullin about something that happened to me. This happened to me personally. Part of it did. And I wanted to ask him, this boy, I don't know that he tried to break in my trailer. I live in a trailer. And I got up here one morning, and my trailer back door was almost open. Somebody pried it practically open. But they didn't get in, because I had several locks on it, you know. And this boy, before that, in this trailer court, he had robbed a lady. Just had moved into the trailer court about 2 weeks, and he took her television, he took a $2,000 diamond ring, and everything. And it's very hard for a person that's any size at all to get in one of these trailers, you know, in through the windows, you know, and things, unless they pry a door or something. So, but anyhow, he took his little brother. He was 11 or 12 years old. And he took him and put him in the window and let him open the door for him. And he went in there and took all his stuff and took it, and they found him. And he lived right here on the next street. I ain't going to say no names or nothing, but he lived on the next street from us over. And so they, when I had called for somebody called and they told me to call the sheriff, you know, about my almost broke in, you know, that they didn't get in, but they almost did. And so they had me to call this sheriff, and I called the sheriff. And this boy, now he went up before he wasn't before the jury or anything like that, I don't think, but he went to this court. And this sheriff that was here at my house, he told me about it, was talking to me about it, and had this boy. He's the one that caught, you know what I mean, that had caught him and had found the material that he had stolen. And he had it in court and all that for evidence, you know. And this boy had 3 other counts against him where he had stolen in different places and done different things, you know. And he was a young man and married and had a baby and was looking for another. And so they took this boy, and this sheriff was telling me now that he was up there and he was the one that took care of it. And he said they took this boy up there before the judge. I don't know what judge it was, but he didn't tell me, but I didn't ask him. And he said that this judge, he had 3 papers full that he had done, 3 papers, besides what he had done, you know, here in this trailer court. And so, and I don't know whether he done mine or not, but I think that he did because he had gotten out in the meantime, see. And so he said to him, the judge said to him, he got up there and he showed him all the evidence and had all the evidence there to show him. And he had these other 3 papers that he had done before all this had come up. That he had done. And he said that he went up there to the judge, and the judge talked to him, I guess, or whatever they do, you know. And he said to him, well, you can go. And this sheriff said, he told me, he said, well, he says, do you mean he's out on bond? He said, no, I mean he's free to go. And now what do you think of something like that now, that he's had several different things against him and broke in and took this woman's things? And, of course, my trailer was broken, but I don't know whether he done it or not. Of course, I couldn't swear to that because I don't know. And I wouldn't say because I wouldn't want, you know, if I don't know anything, I'm not going to say anything about it. And, but now what can you do about that? Or why did that judge let him off free?
I have no real idea, ma'am. I'd have to know a good deal more about the facts in that case before I'd render an opinion.
Now, this is what the sheriff told me. And he told me that he had him up there before, and that he had went and took him up there and had all the evidence to show that he had stolen it. And he run off, and then he come back, see, and he caught him. They caught him. And he come back to work, his place where he had worked. He'd been out of work, and they called him back to work. And that's how come the sheriff caught him. He'd been in Kentucky. He'd run down there to Kentucky. And he couldn't, and the little boy, from what I heard, they took him, I don't know this to be the truth now, I just heard this. But they said they took the little boy to the juvenile, center. But they let him out, I guess, after they found out that his brother, had him to do it. He was a lot older than he was.
Well, wait a minute. We're dealing with enough facts only to make any kind of a judgment on it.
No, I'm sorry. I would like to help this lady. I can tell she's a concerned citizen. She's bewildered by this result, but it would be beyond the scope of anything I could do to even render out an opinion on that.
I don't know his name. He just told me he'd come here to inspect mine when they tried to break it for me. I had to have a whole new door and everything, and they had to, and he had tried.
Well, ma'am, I think we're... I don't mean to cut you short. I think we've gone over the things, and as Oni mentioned, you're a concerned citizen, fine. I think the problem is, it's like trying to make a judgment on any case where you're hearing one side of the facts and then a lot of supposition and assumption and ifs and maybes, and you just...
Until I know it to be the truth, but I'm just telling you.
I suggest for an answer, you probably ought to call the judge and ask him.
Well, I don't know what judge it was. I never tried to find out, what...
But I think we're, I'd like to get some other callers in, and we're giving you a chance to have your say, but it's impossible for an attorney to make a judgment on the facts.
I didn't know. Well, I didn't know. I thought maybe that you were, closer to the law, maybe some way or another,
Well, each case is individually different, and there's just no way to know till you.
Anyway, for the time.
Okay. Thanks for your interest. Bye-bye. WNTS, you're on the air.
Good morning, Ron.
How are you this morning?
Fine, thank you. I'd like to ask Mr. Mullin if Judge Wilson is taping all of his cases now.
No, ma'am, he is not. He carefully explained on the teleconference.
I didn't hear that. I just heard the program
last night, and he has said before that this takes a great deal of money. There's no authorization for it in our statutes. There is no court order to that effect. He is simply getting grants as he can from legitimate sources to try to promote what he hopes would be a noble experiment in trying of cases and the taping thereof, and he's not taping nearly all. A very small minimum of 1% of the cases might have some segment taped with the agreement of the parties. No, he's making no pretenses that this is a universal thing at all.
Well, I am supposed to report on Wednesday morning in his court as a possible juror, and that's why I was wondering.
Well, if you do, and when you do, you will see the videotape equipment, some of it set up in the courtroom, and other huge screens and things out in the court office where you report, and you'll be very interested in the bulk of it and the obvious expense of it, and whether or not they would tape any part of any trial that you might be concerned with. I couldn't tell because they're not taping very many.
Is there any way I could find out ahead of time what trial it would be or how long it might possibly take if I was selected?
I'd rather not get into that. The judge has made a court order that you appear.
Yes.
He's going to expect to see your smiling face there, and then once you get there, the girls in his office and he himself will be very nice to you and tell you anything you want to know.
Well, I was on a jury, a murder jury. It lasted 3 weeks quite some time ago. And since it lasts long, I would be concerned about arranging work and so forth. That's why I was wondering. Like the taping part from the jurors' point of view might be easier if you have to go down and work on weekends, if you're in going to be on a jury.
Yes, I can see that point.
Going to maybe lock you up and you can't go to work, then your employer might be concerned to know about that ahead of time. That's why I was wondering.
Well, I'm afraid I can't answer that because the way court schedules are, and with plea bargaining in vogue, you might show up there and they think it's going to be a robbery case to be tried, but that'll be settled and they'll go with a theft case, a murder case, a burglary case, or something like that, and no one can predict. And since you are under court order to appear, I know you will, and you'll find out firsthand.
Thank you for your call, ma'am.
Okay, thank you. Bye.
Back on the air with Owen Mullin. Oni, I want to thank you again for taking all the time out. And we've covered a couple things. One other thing, a lady called earlier, wanted to know about your courtroom practices. Indicated that you were kind of the Perry Mason of the area. Indicated perhaps some flamboyance, or maybe that would be a poor word, but a lot of histrionics involved to get your points across and so forth. What are your beliefs and what would be your advice as to young attorneys coming up on that?
Well, to avoid imitating anyone. I have been accused, some people say, and it's been proved, they say, beyond a reasonable doubt, that I'm supposed to be somewhat flamboyant, which was not a poor choice of words for you. My secretary, Bobby Kennison, tells me that that's Mrs. Nick Kennison. She tells me that a lot of people say that, and then I've heard it too. I say this, that I do try to give the client a little more than simply, I'm an officer of the court bit and I'm going to behave myself, and if that witness calls you a no-good crook and a murderer and a burglar, I'm not going to get involved in that. No, I'm not that way. I do get involved and I do try to stress my points. I must say this, that sometimes this doesn't work. Once in a while it does. Apparently it works more than it doesn't work.
Okay, we'll go back to the telephone. You're on the air. Thank you for calling.
Yes, I have a question. I was wondering, my understanding was that a couple of thousand years ago that when a jury was chosen, 12 men were taken, or 12 women, because of the signs of the zodiac. Now, I know they don't do that anymore today. They don't ask when you were born. But don't you think that a majority of 12 is too much to find somebody guilty? Why not just 7 out of the 12?
That's a practice which is becoming more prevalent throughout jurisdictions other than in Indiana. And number one, there's a tendency in Indiana even, and in the federal courts, to go to 6-man juries. Now, on the non-unanimous verdicts, that's getting to be the case. We got our jury system from the old English common law system, as you well know. Now, I had not heard before that the sign of the zodiac accounts for the fact that we have 12 jurors on the jury. I've read tome after tome of learned articles as to why 12 was ever selected in the first place. Why not 11 or 15 or 6? But historically, we got 12. Now, in England, nowadays, and this is where we got the scheme from in the first place, the judge instructs the jury to return a unanimous verdict if they can. If they come back and say they're 10-2 for conviction, he can say that's good enough. And in civil cases, particularly automobile accident, collision cases, negligence cases, as we call them, it's been the rule, I think, in Wisconsin for years you didn't need a majority, anything but a majority verdict.
Well, the Supreme Court, how long has it been since they haven't needed or did they ever have to have a unanimous decision?
The United States Supreme Court? What did you say, sir?
Did they ever have to have a unanimous decision in the Supreme Court?
Did they ever have to have a unanimous?
Oh, no. There's plenty of provision in the Constitution for them to disagree as much as they want to, and they certainly have taken advantage of that.
Going just to the majority, I think that's enough.
They often just have a plurality, sir.
I see.
Yeah.
Well, thank you very much.
Yes.
Thank you for your call. In Indiana, then, you don't have to have all 12 for...
Yes, you do.
You
do have to have a unanimous verdict. There is authorization in civil cases for a 6-man jury and in justice of the peace court cases.
I know. Authorization would be by agreement of both parties?
Well, most frequently, yes. That's our system now. In the JP courts, it's the law, 6-man jury, but we're losing those courts, and I'm not sad about that.
In criminal courts, you have to convict beyond a reasonable doubt.
On evidence as to each material point.
Right.
Yeah.
Now, in civil cases, it's the preponderance of evidence, or what they feel, if you were to put them on a scale, if it weighs more one way or the other, but not completely. There's no... the reasonable doubt is just that. Beyond a reasonable doubt.
More than a preponderance, much more, I say.
Yeah, preponderance would be, in other words, who do you believe, and even if you may have some question in your mind, you can go ahead and make your decision.
That's right.
Yeah, okay. WNTS, you're on the air. Go ahead, please.
Yes, am I on the air?
Yes, ma'am.
Yeah. Well, number one, I just wanted to compliment the man for his viewpoints on the system, which I think is fair. And the only way you could do it in the fact that you simply have to have an adversary system. You have to have total truth and total guilt, and the two people pitting themselves. And out of this, if the lawyers do a good job, I think this way truth will come out. And I think this is what he's been...
Hopefully, at least that's what they're trying for in the system.
Yeah. And number one, I wanted to ask a question.
Go ahead.
Yeah, on the Roberts trial, when they chose the jury, I thought it was really unusual in the fact that after they had chosen the jury and chosen the alternates, that they had 2 jurors come back almost immediately and asked to be excused, which
that did happen, yes, ma'am.
Yeah, actually left you with 1 alternate.
Well, as I understand, one juror, after the couple or 3 days of jury selection, did not quite understand. Now, the man that was on the jury that called here knows this story better than I do. I was just an onlooker. I understand one person didn't realize what sequestered meant and didn't want that part of it, and the other person said, after hearing nothing but death penalty propositions for 2 or 3 days, said he didn't believe in that system. So there you are. It is true that the judge was left, after he'd sent everybody else home, he was left with 3 alternates, settling to find that he only had 1. It was not his fault. He couldn't let them serve after they made those statements.
There wasn't anything you could do at that stage of the game. I just thought it was peculiar because the Manson trial that went, 10.5 months, with only 6 alternates.
Yes, ma'am.
And this was only a week.
Yes, ma'am. The long trials that you read about in the other jurisdictions and in the federal courts, however, are generally not compressed into as many hours of the day as ours are. Our judges have a tendency to run a little longer, particularly when the jury is sequestered, to work on weekends and Sundays because the jury can't do anything anyway, whereas they seem to take their time in the federal courts and in California and New York and New Jersey. And those cases have a lot of traffic on criminal cases. I agree with you. It's amazing, if true, that they got by in the Manson case with only 6 alternates in that case. I didn't know that. I'm surprised they did. I thought they would have more than that.
I would think so, too, over such a long period of time. Well, that's all I wanted.
Thank you for your call. WNTS, thank you for calling. You're on the air.
Mr. Holford.
Yes, ma'am.
I want to ask your guest. I mean, I know so little about the law because I thought perhaps the first thing that he would do would be to try to find out if the person was guilty.
You mean if his client was innocent or guilty?
That's what I thought, but so be it. You know, I didn't know that. I suppose that's important. But I was going to ask him about this also. Now, his personal, private life is none of my business. But since it had been brought out about the tax, now what if somebody had been clever enough and had said, now I know a way that we can fix that up, that nobody will ever know the difference, and we could just say that that was an error. Now, how would you have felt about that?
Ma'am, that thought never crossed my mind. Believe it or not, when you're a defendant yourself, your thinking is so entirely different than when you have an attorney. I never and for once thought about even trying to get someone to get me out of it or anything else like that. I don't handle cases that way in my own private practice when I represent others, and I never thought of it in my own case, and I don't think it's possible. I just don't think it's possible.
Now, I don't think that you would ever have, had wanted that to happen. And this is what I was trying to get across. Now, like this Sarah Jane Moore, I admire her for saying that she was guilty. And, I would think it's ridiculous what she tried to do, and I surely wouldn't approve of that.
No, she tried to kill a human being, and the fact that it was the president of the best country in the world made it no better for her.
But this is what I was wondering now, is there? Now, you have what you do is important. But now, is there a chaplain that has a chance to talk to these people and tell them to be honest would be the best policy and for their own peace of mind the rest of their life? Now, if they were guilty, to say they were guilty and to maybe try to give their idea of what happened in their lives that would cause them to do such a thing.
Well, I understand your viewpoint, and it's an honest one. Let me tell you this way. So under former Sheriff Eads and now under Sheriff Broderick, there are several chaplains, very fine men at the jail. But they follow the same rule that the deputies do, that the police do, that other persons do, the bond commissioners and all. They don't give legal advice. They will give spiritual comfort, of course. They tell the fellows to pay attention to their attorneys.
I see. I'd like to be a person that would have an opportunity just, to see something.
Once you contact one of the chaplains at the Marion County Jail, you'll be delightfully surprised at the caliber of the people they have down there. And they're like you. They're not down there for the money. They're down there trying to help their fellow man. It's an inspiring thing, I think.
Oh, I don't...
The Indianapolis Police Department also has a chaplain corps of various ministers and a priest. They don't give legal advice, but they certainly are great spiritual aid to the fellows that run into trouble with the Indianapolis Police Department. I'm very proud of that part of the system in this county.
I think that would be important, and I do thank you.
Thank you for your call. WNTS, you're on the air. Thank you for calling.
This is the first time I've called into your program.
I'm glad you called.
And I've enjoyed the guest that you've had on, and he seems like a very intelligent attorney. And I have one question to ask him. How does he spell his last name?
M-U-L-L-E-N, is that right?
I-N.
I-N.
The rich side of the Mullin family spells it E-N.
M-U-L-L-I-N.
Well, the reason I asked him, that used to be my maiden name.
Oh, well, you're a fine lady.
You're Irish?
Yes, I am.
Okay.
And my people on my father's side were all Catholics.
Well, we were Catholic all the way through and are, and we're from County Mayo in Ireland. County Mayo, God help us, the poorest county in Ireland.
Well, of course, I don't know where my grandfather or anything, really came from. Anyway, I'm originally from Newcastle, Indiana.
They have a fine judge over there, by the way, a circuit court judge. One of the best judges in Indiana, Wesley Ratliff, the circuit court judge of Henry County. Fine man.
I've been away from there about, ever since 35, so.
Been a couple years.
Oh, yes, just a couple of years.
Listen, thank you for your call. We appreciate you calling.
All right.
Bye-bye. WNTS, you're on the air. Go ahead, please.
Is that?
Yes, ma'am.
I would like to ask a question. A couple of weeks ago, a member of my family's house was burglarized, and the youngsters that broke in were caught inside and fingerprinted, and they threw eggs and just complete chaos. And I was wondering if you could give me a reasonable explanation why they are out now. Those boys are out, and they have confessed to 30 burglaries in that area.
Ma'am, again, I lack knowledge of the specific facts of the case. Now, here you are, a householder, been discommoded, been put to great expense, which is just another argument for something I favor called the Victims' Compensation Program. And here are the young men that you say have confessed to this?
Right.
In open court or just to...
They have to appear in court in February, but what reason do the neighbors have to feel that they won't be back before February?
Well, ma'am, you know, the purpose of letting a person, keeping a person in jail or letting him out, the judge makes a judgment call on that, makes a value judgment, that's been brought out in another connection here, as to whether or not these people will appear in court. Now, committing another crime while on bond, or if you're released without a bond, committing another crime since July 29th of 1975 is a separate crime in Indiana. If these persons commit any other crime and it's proved beyond a reasonable doubt, then they'll do the time for their first offenses. And when they get through with that, they'll do the time for the offenses that were committed while they were out on bond.
Well, these boys
That's the legislature's effort to solve the situation that you just mentioned.
The boys were quite young, and they were released to the custody of their parents, but I feel probably the trouble is with the parents, and I can't see why they would let them out within 2 weeks, you know, when they've confessed.
Probably because they haven't been convicted. Listen, I hate to run, but I've got to thank Oni and then get out of here for the news.
All right,
thank you for your call. Only it would have to be probably because of that. Listen, I just want to take a moment out to thank you for taking 2 hours of your valuable off time, and I know you guys do work hard, and coming down to talk to us at WNTS. And believe me, you've been an excellent guest, and we really appreciate your time. And you tell that turkey partner of yours, both of them, Fuller and Gilroy, that I send my best, and we'll look forward to talking to you later, okay?
Thank you very much.
WNTS Indianapolis.
News of the hour on the hour from American Information Radio. This is George.